Hey there, this is Todd Watley. Thanks for watching my YouTube channel. And as always, if you want to be given updates of when a new video is posted, you can always subscribe and like our page, and that way you'll know when each one comes up. All right. I want to continue talking about one of my favorite topics because I think it's one of the most important topics, particularly as an elder law attorney, and that is powers of attorney. And so you've probably seen I've done a whole bunch of videos on that, and will continue to do more. And if you want a topic that you don't see me cover, please let me know and I'll cover it. Today's topic is going to be, I'll say it's a little controversial. I don't know why, because it follows the rules, but it's controversial because attorneys typically don't follow this, and it makes them nervous. And also, if you're the public, understand this topic is going to be a little more technical. It's primarily designed for attorneys. However, if you're the public and you're not an attorney, don't turn it off. Please stick with me, go through this, because you need to understand this so that when you're talking with your attorney and they bring up probably something that I will discuss, that they're like, oh, you can't do that. You're like, yeah, I think you can. Please understand, most attorneys, unless they're a very experienced certified elder law attorney and done this for years, they are probably not as up to date on this as you will be once you go through this. I know, huge introduction. The issue that I want to get into is, when is too late to sign, okay? When is it too late to execute a document, all right? And particularly a power of attorney document. And why this is important is, I think a power of attorney, if you've not watched my videos, let me just go through this real quick. A power of attorney is the most important document that an older person can do, because it preserves your rights. It allows you to continue to have your freedoms, but it lets someone else do things for you. And that's crucial because we don't want to go through a guardianship. And a guardianship occurs when someone truly becomes incapacitated and can no longer sign documents, and someone needs to step in and help them. Our only option is court. It's expensive. It's humiliating because we prove the person's incapacitated with, doctor's reports, examples. It's just a very humiliating process. And it is my opinion, and the opinion of a lot of very well-known elder law attorneys, that guardianships are overutilized because people don't understand the issue of capacity and when it's too late to sign documents. And that's what I want to get into. All right. So an attorney has to follow their ethical rules regarding this. And what may surprise people is, it is up to the attorney to make the decision if a person has capacity to sign. All right. It's not the doctor. A doctor does a medical capacity. An attorney does a legal capacity. And granted, attorneys are not trained in depth about psychology and psychosis and mental defects and things like that, but they are given the ability and the responsibility to determine if their client has the capacity to sign documents. That capacity, what will surprise most people is the capacity can vary depending on the risk of the document. And if you're an attorney, I know your head's about to explode. Probably you're like, wait, what? If you go back and look at your court rule, your ethics rules on capacity, read the rule, but then also, if you have the typical ethical rules that most states have, you get to comment 6. Comment 6 is where it discusses the different levels, and it uses some very interesting language. You're like, where did they come up with this language? This is not lawyer language. The language they use in comment 6 typically comes from a report that was a conference between physicians and attorneys dealing with capacity. And I do like a full hour-long presentation on this. I don't want to spend that much time here doing it. I just kind of want to jump to the chase. If you have questions, feel free to email me at todd@elderlawinabox.com, and I will be glad to answer your questions, point you to the resources. But for everybody there, please understand, I think a person can execute documents well into dementia, okay? And the absolute determination that a person has Alzheimer's or a diagnosis of dementia and therefore they cannot sign documents is absolutely incorrect. That is not in your client's best interest, and it takes a little more work than saying, oh, they've got a diagnosis, therefore they can't sign. That is not doing the best work for your client. The ethical rules allow us to look at the client and also look at the risk of the document. Let me give you two examples. So Mr. Jones comes into the office, he's aged, he has a diagnosis of dementia, he sits down with you and you say, Mr. Jones, do you know where you are? Yeah, I'm in a lawyer's office. Well, hi, my name's Todd, I'm an attorney and I want to talk about doing powers of attorney. You ask him, what'd you eat for breakfast? He's like, I don't remember. What day is it? I don't know, I'm retired, does it really matter? Okay, what season is it? Well, I think it's summer. Okay, you're close. Who's the president? I don't know, don't care, okay? And you go through all of the questions that you're taught to ask in school. Who do you have? Who are your kids? Hopefully they can answer that. Who helps you with your stuff? Well, my son who just brought me in. Okay. You look at the son, is that true? Do you do stuff? And the son says, I'm here because the bank has been letting me do stuff, but they told me that I needed to get power of attorney so that they're covered and that if dad gets worse, I can do stuff. Okay, that makes sense. So dad obviously has dementia, obviously is fairly well progressed, but when you say, who's this person sitting here? That's my son. Are you okay if we give him the power to handle your banking transactions, your financial affairs? He's like, well, yeah, he's been doing it for years. That's fine. Again, he doesn't know what he ate for breakfast, is not very well oriented to time or place, okay? But he knows that's his son, and the son's been doing it. Now, if you're the attorney who says, oh, he has dementia, he can't sign those documents because he doesn't know the president or what he ate for breakfast, what is the alternative, okay? We say, sorry, I can't represent you. I can represent the son. Let's go to court. Let's get a guardianship. Let's spend $4,000, $5,000, $6,000. Humiliate this man for what? When you go to court, the judge will appoint the son, more than likely, as the guardian, take away dad's rights, give it to the son, and now he is able to handle financial affairs, all right? What if you say, okay, I understand that you have dementia, you do know your son, if I do a power of attorney and he signs it appointing his son, that power is very much similar to the guardianship power, and we did it sitting at our desk and protecting our client's ability to not be humiliated, to still have his rights. And that's our goal as elder law attorneys, is to protect the rights of the elderly. And doing a guardianship completely violates those rights. And in that example, when the son brings him in, who's been doing it, it just makes sense that the son should be the power of attorney. And so why should we not let our client sign a document that does that? Why do we force them into court to get almost exactly the same result, but after humiliation, the loss of rights, and a ton of money? All right. Now, example 2. Same dad, same person, although he brings in his caregiver who's been there 6 weeks. All right. Mr. Jones, hi, what'd you eat for breakfast? Don't know. Who's the president? Don't know. Who do you want to be your power of attorney? Well, I want Leslie, my new caregiver. Okay, tell me about Leslie. I don't know. She's just my caregiver. She likes me, and I want her to be my power of attorney. That is what is known as a high-risk document. Now, should we never appoint Leslie as the agent? It is going to require a higher level of capacity by the client to appoint Leslie. If he's able to explain to you, well, Leslie is the daughter of my pastor. I trust them. I've known her entire life. I'm good friends with her father. He's my pastor. I trust her. I know her, and I think she would do a good job. My kids are nowhere near. They don't talk to me. They don't come by. And Leslie, I think, would do a good job. Okay, well, that's a higher level of capacity than the original example. But if he cannot explain to me that those things I just said, then chances are I'm not going to let him appoint Leslie as the agent, because that's a high-risk document. The first document with the son is a low-risk document, and there is no reason we should not let Mr. Jones execute that power of attorney for the low-risk document, where I think we can say, Mr. Jones, your capacity does not allow you to do this document because it's a high-risk document appointing Leslie that you've only known for 6 weeks. All right? Now, go back and look at comment 6, and as you read through that, with that in mind, those comments now make sense, because it allows us to have a sliding scale of capacity depending on the risk of the document. Look at your rules, look at the comments to your rules, and see if you're allowed to sit with your client and not just strictly look at his capacity and say, oh, he has a diagnosis, he can't sign documents. No. Look at what he wants to do, who he wants to appoint, and does it make sense, and is it a low-risk document? If they are doing a high-risk document, they require more capacity to explain to us why they want that person to be the agent under this document. All right? Yeah, your attorney is going to probably have a problem with that if they don't do elder law, but when I've given this presentation to rooms full of attorneys, a lot of attorneys who have done elder law said, Todd, thank you. I thought I could do this because it just made sense, but you've given me the tools by looking at the ethical rules, typically it's rule 1.14, look at the comment 6, and look at that language and now understand where the language came from. This was a recommendation by a group conference of attorneys and physicians to say just because someone has a diagnosis doesn't mean they can't sign documents. Inquire deeper, figure out, help them to have capacity, and then give them the benefit of the doubt to say, this is a low-risk document. We could spend a lot of money, a lot of time, a lot of humiliation going to court, getting almost exactly the same result. Let's just do it sitting at the table. All right? If you hugely disagree with me, let me know. Todd at elderlawinabox.com, and we can have this discussion. But otherwise, hopefully this will help you as an attorney, but also the public, to make sure that their attorney, when you go in with your loved one who has dementia, they're like, oh, we need a guardianship? No, find a new attorney. All right, thanks.